Hi guys, welcome to my YouTube channel. This is official_Joel TV. Today we'll be running through tricks to sue the likes of Dangote and multinational companies like Coca-Cola, Pepsi, and all sorts. Well, what you need to know is that to sue this kind of people, first you need to have probable grounds. Now, what are the probable grounds that might help you in suing this kind of people? The first is vicarious liability, second is negligence, and third is duty of care. Starting with vicarious liability. What is vicarious liability? Vicarious liability simply means a liability that is inferred from the employee to the employer, meaning a liability generated through the employee to the employer. Well, the rationale behind this is that the liability sort of protects the employee and sort of blames the employer. Now let's break it out. For instance, if let's say an employer employs an employee like a driver, then sends this driver on an errand. Then during the course of this errand, the driver brings harm to a third party. It is in this third party's right to sue the employer and not the employee. By suing the employer, we mean suing the person that hired the driver. Now we can deduce how then we can sue the likes of Dangote, Coca-Cola, Nigerian breweries, Pepsi, and all these multinational companies or whatsoever. Now, to successfully sue and get damages from these multinationals like Dangote, Pepsi, Coca-Cola, and all sorts, there are certain things that need to be in place or be proven. The first is there must actually be an employee to all those Dangote or whatever name is pegged to their employment. There must actually be a tort that has been committed, and it must be in the course of carrying out an assignment during the course of their duty or their employment. Now, when this is on ground, then it is very suitable to sue them and get damages for whatever error they have committed or whatever tort they have committed to you. The other way to get money from all these multinationals and Dangote is through their negligence. For example, let's use the case of Donogu versus Stevenson as a point of reference. In this case, a woman walked into a cafe, got a drink, then she was served. She was served from an opaque bottle. Opaque means something that is not transparent or translucent. So, she was served in a tumbler from the bottle. She downed the first tumbler, then wanted a second tumbler after satisfaction. Then while she was being served the second tumbler, a decomposed snail came out of the bottle, of which she has already taken a tumbler from that same bottle. She fell ill and she was diagnosed of chronic diarrhea, gastro, and shock. She then sued the manufacturer, Mr. Stevenson. And during the course of the argument, the court tilted favor towards Mrs. Donogu and ensured and mandated that Mr. Stevenson paid the sum of £550 in damages and remuneration. So in essence, what I'm saying is, whatever it is that you notice that these multinationals owe to you, because they owe you the right to look after you because you are using their product. So let's say you get their product and it affects you, or you bought their product and you are finding something that is not meant to be there. Let's say you bought a Coca-Cola bottle and you're finding a dead mosquito inside or a cockroach. If you take it and it affects you, all you have to do is you have to prove that you have taken it and it has affected you, and this is what damage it has done to you, and you are not okay with the damage it has done to you. Then you have a case and then you can sue.